I'm honored to introduce before you Advocate Rahul Kothari, sir. He's pass out of our own institution. He's practicing in Bombay High Court. He has certain matters with Supreme Court of India, and at the same time, he is into corporate practice as well. Today, I requested him to share his thoughts on drafting of writ petition, mainly writ of mandamus. And please remember that on the knowledge that you would be accumulating on writ of mandamus, you will have to submit one internal, the first internal test will not be happening on in public law. And the notice in this regard has already been sent to you. So there will be a drafting exercise on public law skills. And today we are beginning with the guest lecture series because me and Shruti ma'am already have taken certain lectures and we have tried to clarify certain initial aspects in relation to public law, scope of practice under public law, etc., etc. So without much ado, I request Rahul Kothari sir to come and start sharing his views on public law skills. Thank you.
Hi guys, good morning. Uh, so first, I'd just like to start with compliments to our law school because when I was a student of the law school, we didn't have this subject in the manner it is being taught to you today. So the advantage of having practicing lawyers coming, delivering lectures to you, I think is a significant benefit that you tend to have as students, and significant amount of value that you're getting, and probably you may not be able to recognize that value at the moment, but I can assure you there's a significant value to it. In fact, interestingly, the professor who just taught you, Professor Hartalkar, he was the same professor who taught me my CPC. So in fact, I owe him my entire understanding and foundation of CPC. So he was one of the few practicing lawyers who actually ended up coming and teaching us about various subjects of law, and in his case it was CPC. So I think, as I said, full compliments to uh, the law school for giving you the ability or giving you the exposure to this kind of an understanding. So, like for example, my understanding of writ of mandamus came in probably my second or third year of practice, and not during law school. We had the theoretical understanding of what the five writs were and all of that, but in terms of how do you draft it, what do you present, what do you say, what not to say, is something that typically we were not taught. And I think it's important for you to understand, gain, and um, create value out of the fact that somebody with some amount of experience who's gone through the trials and tribulations of filings to be able to deliver this lecture. So I hope that I'm going to be able to add that value to you. Now, when Vasmatkar sir graciously invited me for this lecture, initially the discussion was that I was supposed to deliver a lecture only on the writ of mandamus and drafting of a writ of mandamus. But I feel that you as students need to understand general tips for good drafting, because without there being a good foundation being laid upon you to understand how you should draft, I don't think you will be able to, because these are generic tips that I intend to give you, which I think will create a good foundation for each of you to understand what you should and should not do as far as drafting is concerned. So when Vasmatkar sir asked me for um, this lecture, I insisted that I will spend about 30 minutes on, before getting into the writ of mandamus, I will spend about 30 minutes on certain tips and suggestions that I have on drafting. And again, I feel that this is an important stepping stone for all of you to understand how drafting is to take place. Now, you have to understand that drafting in general is a draftsman's skill. Okay, so there is no absolute right or absolute wrong way of drafting. But over a period of time, you will realize that you will notice good drafts and you will not notice the drafts that are not very good. And that is where the separation lies. And I'm hoping to impart a certain amount of value to you, to hopefully imbibe to you certain points, tips, and tricks which you can take forward as far as good drafting is concerned. So that is something that I thought I will start with first. Now, before I start with the substance uh, of the lecture, I just had a couple of kind of pointers that I wanted to give you. As far as questions are concerned, there will be a time at the very end that we will dedicate to question and answers. But at any point in time, you want to ask me anything on the topic that we are discussing, please put up your hands, and I'm happy to take a pause there, take your questions, and explain anything to you. As far as my class is concerned and as far as my topic is concerned, there is nothing like a stupid question. Okay, so feel free to ask whatever you need to, with the only request being that let your question be in context of whatever I am teaching. Let it not be too many ifs and buts, because otherwise this will become a semester long lecture rather than being a 2 hour lecture. All right, so as I said, just let it be contextual in terms of your question, but there's absolutely no doubt about the fact that there is nothing like a stupid question. Drafts get corrected. My drafts get corrected by my seniors. I have what could be termed as stupid questions to my seniors, and who have been gracious enough to, correct me and explain to me things in a very patient manner. And that's something that I'm hoping to pass on. So don't feel, intimidated or scared of about asking a question. I'll be happy to take any question on any issue that we are discussing on the topic. Um so now let's start with drafting. All right. Uh, so yeah, as I said, I'm just now getting into the generics of drafting. Now, before I get into what I want to imbibe or what I want to add value as far as you are concerned, can any of you tell me why, as far as you as law students and future lawyers, why according to you is drafting a skill that is important or valuable to you? Can anyone explain to me why? Yes. Yes, please go ahead. Yes. Absolutely. Okay, so one is somebody should understand it. Fair point. Any other reasons why drafting is important as a skill for you? Yes. Sorry, there should be no scope of ambiguity. Yes, absolutely correct. So your drafting should be good enough that it leaves very little room for interpretation, and whatever you intend to say, you say it. Yes. Anyone else? Yes, yes. Oh, yes, absolutely. So there is a possibility, you're absolutely right. There's a possibility that bad drafting can ultimately lead to a negative outcome as far as you are concerned. Now, when I refer to you, I'm not referring to you as law students. I'm referring to you as future lawyers. I'm referring to you as persons holding a responsibility to the client to be delivering a good draft, to be delivering a good um, product as far as you are concerned. Yes, 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 yes. Absolutely correct. Absolutely. Not only, in fact, I will take it a point further. Not only is a petition potentially liable to get dismissed. Yes, absolutely right. And over a period of time, you will learn the technicalities of drafting per high court, per state, which may vary to some extent. But the base remains the same. But more importantly, you will realize that a bad draft or a bad product that you prepare will get destroyed in cross examination in court, because ultimately you have to realize that you are effectively, you as lawyers and law as future lawyers, not as law students, you are being paid for a service. That service is to give a good draft. Ultimately that draft will be tested. Where will it be tested? Typically in a courtroom. Okay, that draft, when it's tested in a courtroom, it's ultimately not you who will be standing there defending the draft. It will be your client, because ultimately what you are writing is not going to be signed by you on oath. You are the lawyer in charge. Ultimately, it is going to be signed by the client or the party who you are representing. So the ultimate consequence lies upon the party. And therefore, your bad draft will not only affect you, will affect your party, will affect your client's interest. And therefore, you have to make sure that your drafting is precise, clean, and clear. All right. Yes, yes, please. Yes, 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 Absolutely, absolutely correct. So drafting is a significant amount of importance as far as you as lawyers are concerned, because you will be drafting. See, you have to think that you're drafting. You're not going to be only drafting as far as court is concerned. You're going to be drafting various documents. You're going to be drafting a sale deed for transactions between parties. You're going to be drafting a contract between parties. You're going to be drafting potentially letters and communication between parties. You're going to be drafting petitions, suits, and various things that will ultimately be before a court. So it's not only a simple document that you need to consider that, oh, when I go to court, my draft has to be good. No, no, absolutely not. In fact, going to court is one of the probably the last things that you will be doing. The foundation of good drafting will lie in your legal notice, will lie in your contract, will lie in the fact that nobody needs to go to court because there is clarity in the drafting that you have done. So therefore, avoiding going to court is in fact a mark of good drafting. You understand? So uh, therefore, I thought it best, as I said, to give you certain tips and tricks as far as drafting is concerned. Now, please remember, this is more generic in nature. My intent of this part of the lecture is not only to give you tips as far as petitions or suits are concerned. It's in general how you should be drafting. That is what is concerned. Okay. So now we've discussed why drafting as a skill is required, but let us just go through a few bullet points of uh, why, according to me, drafting as a skill is required. And you've covered most of these points. As I said, it's one of the most basic requirements as far as lawyers are concerned. You have to realize one important thing is that you will be drafting in different contexts. You may be drafting a legal notice, which will be going on your letterhead. When I say your letterhead, I mean a lawyer's letterhead. You may be drafting communication on behalf of the client, which will be written by the client, but ultimately will be signed by the client, will not be signed by you, but ultimately is a document that you will be presenting. So a few days back, I received an email from a client saying that, there is a potential of a dispute happening on this particular issue between a landlord and a tenant, and I was for the landlord. But I do want to show, I don't want to show the other side that I am being lawyered up, that I have a lawyer on my side. But at the same time, I want to, in my reply communication, because they've sent us a communication alleging certain violations, which has not been sent by a lawyer, but alleging certain violations as a landlord. We want to reply by denying those allegations, but without sending it on a lawyer's letterhead. I want to send it as the client. So therefore, can you please prepare that? So therefore, the language, the tone, the vocabulary has to change significantly as you would be drafting for a client, as you would be drafting for yourself on your own letterhead. All right. So therefore, you have to understand that your role will be significant. You will not only be drafting legal notices, you will not only be drafting suits, you will be drafting emails, you will be drafting communications, you will be drafting various things, keeping in mind the interest of your client and presenting a particular case to the other side, to whatever it may be, under the given context. So therefore, you will be doing legal correspondence, you will be doing contract drafting, pleadings, litigation related drafting, small applications, replies, whatever it may be. Now, it's important for you to understand that drafting is required. One of the points that was covered in one of the responses that was given by one of you was that there needs to be clarity between the parties. So that's your job, because see, in India, an important aspect that you probably have covered as part of your contracts is an oral contract is valid. Now, I don't want to get into at this stage currently what I'm intending to teach you about the specifics of oral versus written contract versus all of that. But my point that I'm trying to make here is that an oral contract is valid. Now, if an oral contract is valid, why do we need a written contract in the first place? So the intent of having a written contract is to cover all possibilities, all permutation combinations, and that is on you to understand and figure out and ensure that it is part of the contract. Because when you get instructions, you will be getting commercial instructions. You will be getting basic instructions. The client is coming to you. Please understand, you are like a doctor. I come to you, I'm saying that I have a fever. Please resolve my problem. It is for you to ask me questions about the fact that, am I allergic to something? Do I have some history? Do I have some problems? Is there some particular cause? That is for you to identify. So similarly, a client will come to you with a set of facts or with a set of issues. It is for you to identify the law, you to identify the permutation combination. So therefore, often we get asked from a business point of view, from a client's point of view, they are always wanting to close the transaction. So they are always looking from a marriage point of view, that how do we get into this? You, all of you, have to think from a divorce point of view. So you have to think of sunrise and sunset, and that is your job. Because in the enthusiasm of a business wanting to close a transaction, they will overlook, typically the business and marketing team will overlook important aspects of what if I don't get paid, what if the payment is delayed, what if the quality that I ordered is not met. That is your job. Okay, so to some extent you will have the law that will protect you under the Contract Act, Sale of Goods Act, and various other laws that may be in place. But ultimately, it is for you to drop important aspects in a contract to ensure you cover all possibilities from sunrise to sunset. All right. So it is for you to think of all the worst case scenarios and try to plug it as best as possible. And this will ultimately come to you with some amount of experience. So you will draft 10 contracts, your 11th contract will be better than the other 10. The other 10 will probably be torn up and thrown away by your senior because you've made mistakes. And that is absolutely fine. We've all been through it. But the point is that you will have to go through 10 contracts, 10 bad contracts, 10 bad drafts by yourself, applying your own mind without copy pasting. And ultimately, your 11th document will be a better document. Okay. Ability to put down thoughts on paper. Again, that's a fairly simple issues. Covers contingencies. Exactly what we discussed just now is that you have to think of all possibilities, the good and the bad, the marriage and the divorce, the possibility of the breach of contract happening, the possibilities of reps, warranties, indemnities, or various other permutation combinations that may apply to that particular piece of drafting that you're doing. Again, one important point that was covered by one of you that responded was that it restricts or provides interpretation in a clear manner. So therefore, I want to create a particular understanding. And therefore, as part of interpretation of statutes, one of the topics that I think you will be learning about, you will be learning the understanding of the meaning, including but not limited to, shall mean, the difference between shall and may. All of that is important as far as all of you is concerned, because ultimately your contract will be interpreted based on this understanding of what is the difference between shall mandatory, may directory, when shall is supposed to be potentially interpreted as directory, not mandatory. Lots of permutation combinations. Ultimately, case law will help you, your understanding will help you. But that's why it is important for all of you to have a very important basic understanding, your basic foundational understanding of how to do proper drafting so that your ultimate product is properly delivered in the interest of your client. All right. Now, I'm getting into general tips for good drafting. Now, again, as I said, this is a general thumb rule. There is no absolute right or wrong. The 10 points that I may come up with your experience, ultimately you may come up with 5 more points, and so be it. But this is a generic, general set of inputs that I wish to give you to explain to you why your drafting needs to be good and proper and clear. Ultimately, you have to realize that it is a piece of communication between two parties, and that communication will ultimately result in it being tested. It may be tested between the parties in a dispute. It may be tested by a court. It may be tested in multiple manners. It may be tested through cross examination, because ultimately what you said in that particular draft on that particular day will be under question. So these are things that you need to understand and put into context. As I said, these are general generic tips for good drafting. Now, it's very important for all of you to understand that you have to have clarity of thought, and it's important for each of you to have that clarity of thought. You have to understand what is your end game. What is your end purpose of that particular draft? Are you drafting a suit? Then you have to understand what is your intent of drafting that suit? What was the violation that happened? What was your cause of action? And ultimately, why are you drafting it? If you're drafting a contract, what is the nature of understanding? Are you capturing an understanding between a landlord tenant? Are you capturing an understanding between seller purchaser? Are you capturing an understanding of movable goods versus immovable goods? What are you doing? Okay. So therefore, your clarity of thought is very important, because what will typically happen over a period of time, and this is a bad habit that I hope that you will not imbibe, is that your intent will get into copy pasting. that let us copy this clause, use it in this particular agreement. Don't do that. The thing is, you have to understand that a contract or a document that you're going to be drafting has to be tailor made. That's what you're getting paid for. You're not getting paid to copy paste. If you're getting paid to copy paste, the client will do it himself and therefore won't come to you. So there has to be some amount of value that you bring to the table. And please understand and appreciate, you're going to be some of probably the best lawyers in the country, hopefully. Now, it's important for you to understand that there is a certain value that you are expected to give to the client. And you are in wanting the good clients. Now, the current set of clients that we are dealing with, which are the good set of clients, I would say, the well-paying clients, are the extremely knowledgeable clients. They are the people who will be sitting across the table with you and debating with you that why this clause, why are we saying this in this particular manner, and you will have to sit and justify. The old school manner of thinking that, oh, my lawyer has done it, therefore he is right, is not going to work today. Okay. So therefore, it's important for each of you to ensure that you bring value to the table, and that value will be tested by your own client. Okay. Consistency in what you're saying. Ultimately, there has to be consistency in your document. If you're referring to the two parties as landlord and tenant, please refer to that party as landlord and tenant and not party A and party B. If you wish to refer to them as party A and party B, do that. But then don't call them landlord and tenant. My point being that let there be consistency in your draft. Okay. Chronology is very important as far as drafting is concerned, because you have to realize that ultimately what you are doing is you are telling a story. And when you're telling a story, you talk about day one, you are born, and day 100, you're dead. And what happens in between. And therefore, it's important for you to realize that when you're telling a story, you need to say it in a chronological manner. Let's say you're before a judge and you're explaining to a judge what happened in that particular matter. Do you start with the breach? Probably not. You don't start with the breach. You say the ultimate, the contract. What was the nature of the contract? What were the nature of the obligations? What was I supposed to do? What was he supposed to do? And ultimately, you get down to the fact that, but he did not do it, and therefore there is the breach or the contravention. You don't start with the breach and the contravention. Okay. So you have to ensure that you follow a chronology in explaining what you are doing. Okay. And this applies more so to court documents than to say a contract, but chronology matters. Okay. Yes. Yes, please. Yes. 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 Absolutely. Yes. Absolutely. You can do that. See, please appreciate and understand that uh, a draftsman skill is a very personal skill. And that's why while somebody may come to me for a draft, I will prepare the draft in a good, competent manner. A fellow lawyer with same amount of experience will prepare a similar draft, keeping in mind the interest, but the draft may look different. And that is completely fine because ultimately the draftsman's skill is a personal skill. So therefore, my intent of telling you all of this is not to tell you that there is an absolute correct format of drafting. So you can do that. So you can pretty much introduce the two parties in the title clause of a contract saying Mr. A, age, occupation, whatever, address, all of that. And you will ultimately say hereinafter referred to as party A or landlord. And then ultimately in your recitals, you will say party A is the owner of so and so premises, who is the landlord in this relationship. So you can do that, no problem. Yeah. All right. Avoid repetition. It's very important for you to understand that a legal document review is not a pleasurable activity, neither for you nor for the client. Okay. So if you want to say something, say it once and finish it off. There are two reasons for avoiding repetition. One is that there is an irritation that is caused. If you're saying the same thing over and over again, it's not going to help anyone. Okay. That is point one. And point number two, when you repeat yourself, there is a possibility that you will contradict yourself. So in para one, you may have said something. In para two, you may say the same thing with a slight variation. That leads to a problem as far as interpretation of that document is concerned. So therefore, avoid repetition. As far as possible, keep your issue to one thought, one paragraph. And it could be one thought, one paragraph. It could be one thought, one set of paragraphs or one set of clauses. Let's say you want to deal with the indemnity clause, deal with everything in the indemnity clause in that clause. Put everything to do with indemnity in that clause. Don't keep moving around the indemnity clause from clause number 1 to 5 to 7 to 8. Put everything in the indemnity clause. Put everything that you want under reps and warranties in the reps and warranties clause. Everything to do with jurisdiction, put it in one clause. Do not spread out your jurisdiction clause as far as possible. Okay. Your drafting has to be contextual and purposeful. This is something that we discussed. Now, just to drive that point forward, let me explain to you with an example. Now, when this invitation came to me today for coming for delivering a lecture, and Vasmatkar sir sent me an invitation, that invitation said that, this is the topic of discussion. This is what needs to be discussed or, taught to the students of our law school, which is all fine. But that invitation did not mention any dress code as far as I am concerned. You may have a dress code. As far as I am concerned, there was no dress code. So in theory, I could be standing here in a Mickey Mouse costume and delivering a lecture to you. But you have to realize that that Mickey Mouse costume, although the content may be exactly the same, will be a distraction as far as all of you are concerned. It's not something that you will accept as somebody standing here and delivering a lecture on the writ of mandamus to be standing here in a Mickey Mouse costume. However, if you go to Disneyland, you will expect somebody to be in a Mickey Mouse costume. You'll be going and standing and taking photos with him or her. But here you'll be saying that, oh, your professor is completely bonkers coming in and wearing a Mickey Mouse costume, although there is no restriction. And what matters, therefore, is context. Same person standing here in a Mickey Mouse costume is a problem. Same person standing at Disneyland with a Mickey Mouse costume is not a problem. And why that is important is context. The context of your drafting is very important. Are you drafting a legal notice? Are you drafting an email communication? Are you drafting a petition? Are you drafting a suit? Are you drafting a written statement? Now, the class that you just dealt with just earlier, CPC. Now, there are certain rules that govern what should or should not be forming part of a suit and what your pleading should or should not contain. Similarly, what your written statement should or should not contain. There are certain rules, and that is what you need to learn, and that is what ultimately is being taught to you. So keeping in mind that context of the fact that you are a plaintiff, you are a defendant, you are preparing a written statement, ultimately you will have to deliver on that particular subject or issue. All right. Now, the old school way of thinking is using very complicated language and using very complicated legal language. Now, this is my personal preference, and something that has worked for me over a period of time is that I prefer using short and simple language as far as presentation is concerned. Now, that could be a contract, that could be a document being or some pleadings before a court, because ultimately you have to realize that at the end of the day, you're dealing with a counter as a human being. You're dealing with somebody who is ultimately needing to understand and implement what you're writing. So you may write extremely complicated legal terms, which the accounts team of your client will have no idea what you're saying. But ultimately, the accounts team of your client will be implementing that contract, because ultimately some payment has to be received or paid by them. So therefore, please try and ensure that you use simple English. Use everyday language. Of course, ultimately, there has to be a formality to your language. There has to be a certain vocabulary that you are expected to use. No doubt about it. So I don't intend for there to be use of slang words or short forms when not needed. But at the same time, keeping in mind the interest of your client, keeping in mind the formality of communication that you need to enter into, ultimately, you need to present a document which is simple enough for a person to understand. May it be your client, may it be the opposing party, may it be the judge, whoever it may be. Okay. As I said, you need to be justifying all points, not only to yourself, justifying all points to your client. As I said, you will be dealing with educated clients. justifying all points, because ultimately you will be dealing with certain negotiations, because somebody will end up countering your contract or your document. And therefore you need to justify why this particular indemnity clause, why a one-sided indemnity clause and why not two-sided, why this particular rep and warranty have you added. And now you cannot go ahead and answer that, oh, because contract A had it, I copy pasted it, and therefore that is my justification. That cannot be a justification, because you need to have a tailor-made document. So therefore it's very important for you to be able to justify all points. Yes, please. Yes. 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 Absolutely. Yes. No, see, you have to understand that when it comes to certain level of documents, like you go to a bank and you want to open an account, won't you have an account opening form? Are you going to use your drafting skills at that point in time, saying that I'm going to junk this form and I'm going to use whatever I want to use? Your bank's going to say, then go to hell. I'm not opening your account. So the point that I'm trying to make here is that when there are formats given, you have to stick to the format as far as possible. But usually, and you're absolutely right about, and it's an extremely good example that you gave about an execution petition and being in a tabular format. But what goes into that particular table is your skill, no? They don't dictate what goes into that table. They will say serial number one, party name, whatever it may be. Ultimately, there'll be a column that says who won, who lost, which is who is the judgment debtor, who is the decree holder, what happened in that particular matter that ultimately you need to execute. Do you have an arbitral award in your favor? Do you have a court decree in your favor? What do you have in your favor that you want executed? So within the four corners of a format that you require to follow, you need to have good drafting. Okay. So when there is a format, no doubt you need to follow a format. But usually when it comes to say a plaint has ingredients that need to be there in a plaint, but there is no absolute format. There is generally a format that you start with the title clause, the jurisdiction title clause, then you move on to introduction, facts, background of the matter, then you move on to what your cause of action is, then you move on to jurisdiction, court fees, various things, and you end ultimately with the prayers. That is generally the format. But within the document, how you do it and how you deal with the document is your skill. And that is what is expected out of you. All right. Uh, Again, very important knowledge of client requirements, because again, as I said, you are expected to be professionals with a certain skill set. You have to ask the client for information uh, that the client may not give you, the client may not think it is important to give you, but which may be very important as far as the document that you're preparing. Okay. So therefore, understanding the document, understanding the context, understanding the fact, let's say, for example, you are drafting a document between landlord and tenant. That will be wholly different than you drafting a document for, say, automotive components being manufactured. Clearly, it will be different. But unless you understand what your client requirements are, how will you ultimately draft a particular document? So therefore, you need to understand client requirements. You need to extract information out of your client, and then ultimately prepare a document based on those instructions and based on the commercials, or based on the intent or purpose behind which you are doing that particular drafting. Knowledge of applicable laws extremely important. As I said, you need to, or you are expected to have an understanding of what is there in a plaint, what is supposed to be there in a written statement, what is supposed to be there in a election petition, as an example that was given just now. That is your job. And therefore, if you miss a particular statement in an election petition, that is subject to dismissal. And that is not only subject to dismissal as far as your client is concerned, but you will never get that client back. So therefore, it is subject to a reputational harm that you will go through. Okay. Formatting, punctuation, presentation, pagination. Again, as I said, legal document is not a pleasurable read. So if you make it in Times New Roman 9, font number 9, single spacing, no space between paragraphs, it's an impossible document to read. However much you may be intending to read it with the best of intentions. Okay. So therefore, make your document presentable, make your document readable, make your document understandable to the other person in a reasonable manner. Reasonable font size, reasonable spacing, paragraph numbers, pagination between in the document, commas. Again, the English language is very funny. Your command over the English language is also going to be extremely important. Now let's look at the screen and let's look at how one comma can change the entire meaning of a sentence. The sentence being, a woman without her man is nothing. Now let's punctuate that and let's figure out how you can differentiate the meaning with commas. A woman without her man is nothing. A woman without her man is nothing. It's the same sentence with the same words, with just the difference of punctuation, which is completely changing the meaning of that sentence. Okay. So please understand and appreciate that English language and having a good command over the English language is extremely important. Same sentence, two completely different meanings based on the punctuation that you put in. And therefore, when some of your seniors will probably be telling you that make sure you dot the I's and cross the T's, this is what it means. Are you communicating effectively what you want to say and how you want to say it? And this is a prime trite example of it. Okay. All right. Parts of a petition, just giving you a basic understanding of what a petition will look like. Ultimately, we will be dealing with a writ of mandamus. I will be giving you a set of facts and I will be explaining to you how that writ is going to ultimately be drafted. I do appreciate and understand that, you know, you are a second year law student, so you won't have a great understanding of drafting of a petition. I learned how to draft my first petition, as I told you, in my second or third year of being a qualified lawyer. So therefore, I don't expect you to have a significant amount of understanding of how a petition is drafted, but I will take you through important parts of a petition, how you present a petition, my manner of presenting a petition. As I said, a draftsman's skill. Okay. Uh, what does a petition look like? First, initially, you will have court and jurisdiction before the Honorable Supreme Court, before the Honorable Bombay High Court, before the Honorable Civil Court, Pune, whatever it may be. Okay. Cause, title, and parties, A versus B, A being the plaintiff, B being the defendant, respondent, appellant, whatever the relationship between the parties is. So the two parties' names. Uh, an introduction. Now, I personally believe that this introduction is very important. This introduction, in my personal view, is a summary of the entire matter in about 4 or 5 lines, which will give context to the judge to understand your entire matter. And in that context, read the rest of your petition. Because ultimately, when you're going to get into the prayers or the reliefs that you're seeking, the judge needs to understand, why are you coming to me? What is the nature of reliefs you want? What is the nature of dispute that is there? And therefore, the introduction will give a snapshot of what is the nature of the dispute and why I am before you. Okay. Details of the parties, what is the nature of relationships, landlord, tenant, seller, purchaser, whatever it may be. So you need to give details of who you are or who are the two parties. Uh, Facts of the matter, again, follow chronology as far as possible. What are your grounds or what are the reasons for you to invoke the writ jurisdiction of that particular court, maybe the High Court or Supreme Court? Um, then there will be some boilerplate clauses. I will be getting into that. There, I would say, relatively standard clauses, and that is where, to a large extent, you will be probably using your copy paste skills. But again, you need to ensure that it's tailor made. So everything won't simply apply just because it's there in every single draft. And then ultimately you end with prayers and reliefs that you're looking for. Ultimately, what is it that you want? Drafting of prayers, drafting of reliefs is extremely important, because a lot of times in moot courts is something that you will face. In reality, we face that a court cannot go beyond your prayers. So therefore, drafting of your prayers, asking the court for what you want, is very important. Because ultimately, regardless of what you have written in paras 1 to 20, your prayer should be appropriately drafted, because without that, the court will not be able to grant you or mold the relief to your requirement. Yes. In fact, I'm going to be getting into that. So I'm going to be showing you, giving you a set of facts, and I'm going to be showing you how that introductory paragraph looks like. Okay, so I'll get to that. Anything else before I move on? All right, so this part of the lecture is done. Again, my intent was to give you a more generic kind of an input on how uh, drafting is to be done. We have about 45 minutes now to get into the writ of mandamus. But before that, any questions, any inputs, any comments that you'd like to make on this first part of what I have intended to teach you today? Any inputs? All right, so let's move on then. Um, Now let's get into a writ petition mandamus. All right. So what are we going to be looking at when we look at writ petition mandamus? All right. Uh, we're going to be looking at a few important aspects of what is a writ, what are the types of writ. Now, my intent here is not to get into the theory, is not to get into the nitty-gritties of writs, because that is what your regular constitutional lecturers will be teaching you about. So that is not my intent. But I'm just intending to give you a bit of a snapshot on this particular topic so that you get the appropriate context to understand why a writ of mandamus is being taught to you or how it is to be drafted. All right. Uh, an important aspect of 226 versus 32. Again, more a practical aspect. I'm not touching 227 because 227 is a whole different ballgame and whole different animal to deal with. And therefore, I'm not dealing with 227 because 227 opens far wider doors than 226. So therefore, I want to stick to 226 read with 32. And ultimately, we will see how 226 is far wider a power than 32. All right. We'll get into what is a writ of mandamus. When do you invoke a writ of mandamus? Uh, Important considerations or points that you need to keep in mind while preparing a writ of mandamus or understanding how to implement a writ of mandamus. Now, please understand today what we are preparing is a writ of mandamus where you are prosecuting, where you are saying, I want the writ of mandamus. There will be situations where a writ of mandamus is filed against you, and ultimately you will have to file a reply. Okay, so that is not what we are looking at just now. But at some point, you will have to understand that understanding mandamus is important because you will have to understand, therefore, your reply, your exceptions, your reasons for why mandamus will not apply, because that will ultimately be your reply. Okay. So that is an aspect and area you need to understand, but it's not something that we are going to be touching upon today. But once you understand what is a mandamus, then you will be able to understand how to reply to it, how to create an exception to it, and how to say it mandamus is not applicable. Okay. Then I will be dealing with a factual scenario. I'll be giving you a live case. I'm dealing with a live case. I've simplified it significantly only to concentrate on mandamus. I've changed the names of the parties and anonymized it to a large extent. But having said that, it's a live case that we are dealing with currently. And we are before the Bombay High Court in this exact writ of mandamus uh, uh, coupled with a couple of other writs. But as I said, my intent is to simplify it. So I don't want to get into the complications of a real case. I want to focus on mandamus. Um, I may deal with a couple of other cases, time permitting, and then ultimately we can end with question and answers. As I said, I'm happy to take in questions, comments at any point in time, even during the course of the discussion. All right. Now, before I sit and explain to you what is a writ or what are the types of writs, why don't you help me with that answer? What is a writ? You guys are second year law students, right? You've touched upon constitution. You've dealt with the five writs. So explain to me, what are the five writs? What is a writ? Sorry. Writ is a court order. That's a little tricky because ultimately I can get a court order from Pune Civil Court also. That does not amount to a writ. So just simply saying that it is a court order is not good enough, because then by that definition, any judgment or any decision that you pull out from Manupatra will be considered a writ, because ultimately that's an order. That's an order of a court. That's a judgment. So every order is not a writ. So I wouldn't agree. No, writ is not an order. Anything else? Any other inputs on what is a writ? What is the command that is being given? What is a writ? Yes, it's a direction. Okay, explain that a little in detail. So if I want to go from Symbiosis to Kalyani Nagar and I say straight and left, is that a RIT? Okay, so then explain to me what you mean by a direction. Yeah, but in general, what is a direction? When you say it's a direction, who is that? Okay, let's start with the basics. Who issues that direction? A court. Okay, a court issues a direction. Again, is every direction then therefore a writ? Because every order is not a writ. A writ. Sorry, can you repeat that, please? No, forget mandamus. Ignore mandamus. Let's take any of the five writs. You want to take mandamus, fair enough. But don't focus on mandamus. I'm not getting into the focus of mandamus at this moment. What? Yes, yes. Yes, to a large extent, you are right. Not always fundamental rights. There are larger rights that can be enforced through writs. But yes, largely, yes, 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 please. Uh, Restoration of a right, not always. Enforced against a state, yes, to a large extent, you are right. There are some exceptions where writs can be against between private parties, but I'm not getting into the exception. It will be far too complicated at this moment for you. So therefore, yes, in principle, it is a command issued against the state. Who issues it? Yes. Excellent, excellent, correct. So a formal command issued by either the Supreme Court or the High Court to protect or provide you remedies against constitutional rights that you have. Absolutely correct. It's not restricted only to fundamental rights. Though a large extent it will cover fundamental rights, but not in all cases. Okay, so there is a wider scope for especially 226. 32 is still restricted to fundamental rights, but as far as 226 is concerned, far wider powers. Okay, now what are the writs that you've learned about? Let's very briefly in a couple of lines tell me the five writs. Habeas corpus. Okay, let's start with that. What's habeas corpus? Sorry. Okay, so very briefly, I mean, just telling a person saying to have a body means nothing really. So unlawful custody. Yes, absolutely. Just being in custody is not good enough. All right. So habeas corpus. What else? Mandamus. Okay, what is mandamus? Commanding a public authority to perform their duty. Yes, absolutely right. Mandamus. Correct. Next. Certiorari. Yes, please. What is certiorari? A certiorari will probably be certiorari and prohibition largely go hand in hand under different circumstances. But what is certiorari? Yes. So certiorari is to quash an order of a lower court or a lower authority. Not always a lower court, but a lower authority. Prohibition is preventive. So certiorari is after the act. Prohibition is preventive. So therefore, they lie in the same or similar area of operation, but one is preventive, one is curative or corrective. All right. And last one, quo warranto. Yes. What is quo warranto? By what authority? But again, that does not really explain much. Sorry, can you be a little louder? I'm sorry. Yes. Yes, to some extent. And you're partially right. Any other inputs? Quo warranto? Usurping authority. Yes, absolutely correct. So that's absolutely right. So, yes. Oh, yes, yes. So please understand, guys, you're absolutely right. Ultimately, when we go before a court, you will go either under one writ or you will go under multiple writs. And therefore, you will do multiple actions. So I will say quash the lower court authority and direct him or her to do something. So therefore, I will do certiorari plus my mandamus. Absolutely right. So there are hybrids of writs also that are there. It's there is no absolute that only one writ has to be invoked under one petition. That is absolutely not the case. In fact, most of the times you will be invoking more than one writ. Okay. But having said that, for academic purposes, for teaching you, I'm going to be doing it in a slightly more compartmentalized manner. And therefore, we are going to be focusing ourselves on mandamus. But please keep in mind that you will be invoking multiple writs most of the time, if not all of the time. Okay. But at the moment, we are restricting ourselves to mandamus. Any other inputs before we move on? All right. Uh, so what is a writ? What are types of writs? Let's get into that. Just you've covered most of it, but just get into the basics. Again, my intent is not to substitute your theoretical teacher on constitution, but just to give you a bit of an overview. It's a command to an authority to do or not to do something. It's the court's role to safeguard persons against arbitrary acts of the state, not necessarily to do with fundamental rights. Most of the times will be fundamental rights, not always. Meant as a check and balance mechanism. This is very important because that's how you need to understand your executive, judiciary, and legislature, the difference between all three, and ultimately, what is the check and balance mechanism that the courts have under the constitution to keep a check and balance on the executive authority of the state. Okay, because ultimately you need to understand where the separation of powers lies, and therefore ultimately what is the nature of power that the judiciary will have upon the executive using the writs without really usurping or trampling upon the powers of the executive in normal course. All right. Uh, Protection of not only fundamental rights but other rights as well. Very important, issued by the Supreme Court and High Courts. It is not something that is issued by lower courts or the district judiciary. It is necessarily having to be done by the High Court and Supreme Court. So therefore, under no circumstances can you file a writ petition, say in the Pune District Court. It cannot happen. Okay. Uh, what are the types of writs? Habeas corpus, which is basically against unlawful detention. Quo warranto, against illegal use or usurping of authority by somebody. Prohibition, prevention, we've dealt with it. Certiorari, quashing, so therefore is a later action. Prohibition is a preventive action. Mandam is something we are going to be discussing, which is a command to do or not to do a statutory act. Most of the times you will be invoking something to do. Very rarely will you be invoking the right not to do something. And right not to do will fall under a similar situation to an injunction. An injunction can be a mandatory injunction or can be a restrictive injunction. And therefore, a restrictive injunction tells you don't do something. A mandatory injunction tells you please do something. And therefore, you are required to do something. So similarly, mandamus is also in a similar thought process or an understanding. All right. All right. Very briefly touching upon 226 read with 32. 226 deals with powers of the High Court. 32 deals with powers of the Supreme Court. Supreme Court largely deals with breach of fundamental rights under 32. The powers of a High Court under 226 are far larger, far wider than, than a 32 under the Supreme Court. Okay, so remember, while Supreme Court is necessarily supreme, of course, under the hierarchy of courts, but purely going by constitutional availability of powers, 226 has far greater powers than a 32. So therefore, when ultimately a client usually will come to you, most of the times you will invoke a 226 rather than a 32. Most of the times. Okay, there are exceptions. There will be situations where you will directly move the Supreme Court. Now, at a practical level, you need to understand and appreciate one important thing. Why, as a lawyer, you would typically invoke a 226 before a 32. Okay. Now, please understand and appreciate. And this is a practical input that I'm giving you. There is nothing that you will find in law books as to why we will do this. But as practicing lawyers, we typically do this. Please understand and appreciate that the Supreme Court is the be all and end all. Once the Supreme Court delivers its particular judgment, God can also not save you. Okay. So there is no remedy beyond the Supreme Court. Now, I don't want to get into curative review petition, all of that. But for now, the Supreme Court's word is the final word. The High Court is not like that. So when you go to the High Court, regardless of what outcome you may have, if you are aggrieved by it, you still have the Supreme Court. Okay, so typically we prefer going to a place where that is not the final word, because then I still have a remedial measure before the Supreme Court. So therefore, typically when I have a two-step mechanism, I'd like to invoke that two-step mechanism and keep that little bit of safeguard saying that, oh, I still have an authority to go before, versus a 32, which will ultimately deliver a judgment this way or that way, and so be it. No further challenge, no further questioning of that particular authority. As I said, there are exceptions. I'm not getting into those exceptions for now. But in principle, thumb rule, Supreme Court, final decision making authority, there is no further appeal, there is no further challenge. And therefore, I would prefer to stay in a high court, potentially get an adverse order, which may not go in my favor, and then move the Supreme Court. Whereas in the Supreme Court, if I get something adverse, I have no second remedial measure. Okay. So therefore, typically, lawyers prefer invoking 226 or 227 under certain circumstances, but 226 or 227 rather than a 32. 226, enforcement of fundamental rights and other rights. Again, please apply your mind to and read 226. My intent is not to, spoon feed you what is 226 saying. Open the Constitution, go to 226 and read it. Uh, it has much wider powers, and again, something that you need to understand in terms of interpretation of the Constitution or interpretation of statutes. You will have something known as a non-obstante clause, which is something that starts with saying notwithstanding what is stated in whatever. Okay, that notwithstanding is an extremely powerful word when it comes to drafting. Drafting, as far as contracts are also concerned, notwithstanding what is stated in the clause above, and you can create an exception. Okay, so therefore, this word notwithstanding is extremely powerful, rarely to be used, and used to be used extremely in an intelligent, intelligible manner. It is not something that you need to play around with simply by using your legal vocabulary. Okay, so please understand and appreciate that the term notwithstanding is very important. You will at some point learn the importance of this term notwithstanding, but it's basically a non-obstante clause. The minute you read notwithstanding as a lawyer, important red flags need to go up in your mind, either in your favor or against you. But this notwithstanding word is very important. Notwithstanding anything stated in Article 32. That is again important for you to realize. Therefore, greater powers come under a 226 than a 32. Okay, so therefore, Supreme Court being supreme, yes, but as I said, under the Constitution, 226 has greater powers. Article 32, enforcement of fundamental rights only. That is where the differentiation lies. The 32 is only fundamental rights. Much narrower scope compared to a 226. That's another reason why 226 is invoked, because you may have fundamental rights, but in your set of facts, you may also have certain other violations that may have happened, which don't fall under the pure understanding or reasoning or rationale of part 3 of the Constitution, which is the fundamental rights. And therefore, it is better for you to invoke a 226, potentially a 227 under certain circumstances, rather than a 32, because 32 only fundamental rights. And the minute you go beyond the scope of fundamental rights, it's subject to dismissal, or they will say you have an alternative efficacious remedy, which is something that I'm going to be discussing about writ jurisdiction. But you have an alternative efficacious remedy. Go before the High Court. Don't come before me as the Supreme Court. Okay. What is a writ of mandamus? Let's get into a brief understanding and explanation on what is a writ of mandamus. It is enforcement of performance and to enforce performance of public duties by authorities. Okay, so a public authority is required to act in a particular manner. And if a public authority fails to act in a particular manner, a writ of mandamus is typically invoked under those circumstances. It can be invoked only when there is a legal duty or obligation for such performance. So let's say, for example, you go to a public authority. That particular public authority does not have a duty to do or not to do something. And then ultimately you go and say, I want to invoke a writ of mandamus, but he never had the authority to do it. Okay. Let's say, for example, you go to a revenue officer, okay, revenue officer of a state, and you say, please sanction my building plan. You can't do it because that revenue officer has no authority to do it. So that typically a plan sanctioning has to happen through what we would refer here as the Pune Municipal Corporation or the appropriate municipal corporation wherever you are from, or could be before the collector, or could be before the Gram Panchayat. These are typically the three authorities that usually end up granting certain rights for plan sanctioning. but you go to a revenue officer and say, I want plan sanctioning. And then you say, oh, he's not giving me the plan sanction, writ of mandamus. Doesn't work. Okay. So therefore, inherently, there has to be an obligation upon that authority to do something. And then ultimately, you get down to the fact that he is not doing what he's supposed to do. And therefore, ultimately, you get down to the fact that you invoke mandamus. Contractual rights cannot be enforced through a writ of mandamus. Say you and I enter into a particular contract. You are required under law. I supply you a machine. You are required to pay me 1 lakh rupees. So it's an obligation or duty upon you. However, I cannot invoke a writ of mandamus against you. Now let's take that example further. Let's say I am into a contract with a public authority. Let's say I am delivering some, say, laptops or computers to the Pune Municipal Corporation. And the PMC fails to pay me my contractual amount. I cannot invoke a writ of mandamus because ultimately it is a contract between two parties. It may, in its strictest sense, it is not two private parties, but ultimately the base is that it is a private contract between parties. And that is not enforceable through a writ of mandamus. Although the PMC has an obligation to pay me, but ultimately you have to understand that it has to have a public duty to do something. And therefore, a breach or violation of a contract by a public authority is not subject to the writ of mandamus. All right. Uh, Usually used as a direction, the court does not sit in appeal of a decision. Now, this is important for you to understand. And this is one of the examples that I'm going to be giving you as part of the exercise that we are going to be doing today. So when I invoke a writ for the public authority to act, the court does not say act in a particular manner. The court will simply say act as you are required to act. Now, the issue that I'm going to be dealing with as a live example is that we filed an application for plan sanctioning. Now that plan sanctioning, ultimately, the authority did not grant me my plan sanction and kept it in abeyance. It was not rejected. It was kept in abeyance. For certain reasons, we'll get down to what those facts are. Okay. And ultimately, a certain amount of time goes by. The authority does not act. I send follow-ups and reminders to the authority. The authority does not act. I go to the High Court. I go under a writ of mandamus. Please tell the authority to take appropriate action. I don't say, please sanction my plan. I want a decision. I want an outcome out of what the authority is supposed to do. So the High Court will not say, please sanction the plan. The authority will say, please take an appropriate decision within 3 weeks, as an example. Okay. So therefore, it's important for you to understand that a court, typically in a writ petition, does not sit in appeal. It is not substituting the decision of the authority in an appeal. In an appeal, the substitution can happen. In a writ petition, it does not happen. Okay. So therefore, it's important for you to understand that a mandamus is not used for telling the authority to act in a particular manner. It just simply says, please ensure that your duty is fulfilled by taking appropriate action on this application within 3 weeks. Okay. So therefore, it is a direction that is ultimately issued, and it is not a decision that is issued that you please do this in a particular manner. Okay. In a mandamus, there is an ability to quash an order in case the discretion of the public authority is not being used in a reasonable manner. And this is where potentially you will see a certain amount of overlap between writs, a certain amount of overlap between certiorari, potentially quo warranto because of illegal use of authority, and mandamus. And therefore, I wanted to start by saying that while I intend to teach it to you in a compartmentalized manner for your understanding, the ultimate outcome in practice is that you will not be dealing with one writ most of the times. You will be dealing with a bouquet of writs depending on the facts and circumstances of your matter. All right. So now, what is it that you typically need to consider while invoking writ jurisdiction? Now, writ jurisdiction, this is more generic. This is not mandamus related, but these are things that you need to keep in mind while ultimately you need to invoke writ jurisdiction as far as the court is concerned. Okay. So this is where your role comes into the picture as a lawyer, keeping these ingredients in mind. And failure of keeping these ingredients in mind will result in adverse consequences upon you and your client. Usually against a public body, I don't want to get into the exceptions of when a writ can be invoked against a private party where public authorities can also be involved. I don't want to get into that. There are certain exceptions to the rule, but please appreciate and understand the rule first, and then your understanding of the exception will be better. Therefore, usually writs are invoked against public authorities. There are certain exceptions. Usually it is not invoked against private parties, but as I said, there are certain exceptions to it. Um, a writ jurisdiction, very interestingly, you would probably have heard of this concept known as the Limitation Act. Now, Limitation Act is your time period within which you have to act to enforce your remedy. Okay, so let's say there's a breach of contract between you and me. You did not pay me for the machine that I delivered to you, whatever that amount may be, 1 lakh, 1 crore, whatever, as per our contract. I have a period of 3 years from the date of the cause of action to be invoking that remedy. After 3 years, I can't invoke that remedy. Okay. However, as far as writ jurisdiction is concerned, that limitation period is not strictly enforceable. However, it is more strictly enforceable because the court will ask you, oh, but what were you doing for the past 6 months? Why could you not have come to me earlier? Why did you come to me now and wait 3 to 4 months before invoking this writ jurisdiction? So, in fact, you don't even have the leeway of 3 years, which the Limitation Act gives you. So, on the face of it, I am telling you, Limitation Act does not apply. But in fact, in reality, you are in a far stricter timeline than the Limitation Act provides to you. Okay, so it's a little bit of a dichotomy that I'm explaining to you. Limitation Act does not apply, so therefore, in theory, there is no time limit. But the expectation is that you need to invoke the jurisdiction of the court within a reasonable period of time, and therefore, it is in fact far stricter than the Limitation Act. Okay. Uh, Check whether there is an alternative and efficacious remedy. This is extremely important as far as you are concerned in invoking a writ jurisdiction. In case you have the ability to file an appeal, you will be required to exhaust all your available remedies before you go for a writ petition. So, a writ petition is basically if you have no other remedy available or left with you, then you invoke 226 or 227 or 32, depending on the situation. But if you have the ability to file an appeal, a revision, some form of challenge, then a writ does not lie, usually. Now, it's very important. There are two important words here: alternative and efficacious. Both need to be fulfilled. So, a lot of times, you will be met with a challenge from the other side, which is my reply to your writ petition, saying there is an alternative efficacious remedy. And therefore, the writ does not lie. That will be my reply. That will be my exception that I'm trying to draw of you getting out of that jurisdiction. Okay. Your answer to that typically would be, yes, it is alternative, but it is not efficacious, or it is efficacious, but it is not alternative. Now, I don't want to get into the nitty gritties of alternative and efficacious, but what I effectively mean to say is that I must have a reasonable alternative effective means of challenge. If I have those, a writ petition does not lie. But if I don't have it, then in that case, a writ petition lies. So a writ petition is effectively, mentally, when you prepare a writ petition, it's your last possible remedy. Okay. When nothing else remains in terms of all your various legal remedies that are available to you. All right. Um, Check for locus standi of the petitioner. Now, the example that I gave you was uh, plan sanctioning. That is the example that we're going to be dealing with. Now, let's say it's my house. I apply for plan sanctioning. Okay. Then typically the locus will lie with, say, for example, I am not available, me, my wife, my son, my daughter, whoever it may be. But a complete rank stranger cannot file a writ petition saying that his plan is not getting sanctioned by the authority. So therefore, locus standi is important to understand and recognize who are you vis-a-vis the matter, And ultimately, the court will question, who are you? What is your competence before me? And why should I grant you the reliefs? Okay, so locus standi is a little important. Now, if it's a public issue that you are taking up, say potholes in the roads or drainage related issues, then locus standi, the threshold of locus standi goes significantly lower, because then a resident of Pune can do it. It's not necessarily that is to be invoked by only a person affected, simpliciter. Okay, so therefore locus standi needs to be again seen in context. So context is very important while determining locus standi, and you as lawyers will have to have an important part to play in determining whether there is locus or there is no locus. Okay. Um, and then be clear on the facts and grounds. Do your research. Again, extremely important step. Your first action should not be let's draft the writ of mandamus. That's the last action you should be taking. The foundation that you should be creating is that let us question, does a writ of mandamus lie? Do all the ingredients get fulfilled? Are all the facts and circumstances correct? Is there an alternative efficacious remedy? Can I do something else? Have I written the correct amount of reminders? Am I going potentially too late to court? Am I going too early to court? Am I being premature in my outcome? Because let's say, for example, that the authority has, let's say, 30 days time to sanction your plan. And you run to the High Court and say, I'm going in 15 days. See, is not sanctioning my plan. That's premature, because the court will end up telling you that why are you coming in a matter of 15 days when the authority has 30 days to take your decision? Okay. So therefore, are you going too late? Are you going too early? All of these issues need to be considered. Potentially research on similar matters of mandamus need to be considered as far as all of you are concerned. Because please appreciate and understand that when I come to you as a client, I am coming to you with no knowledge. You are the person who is expected to have the knowledge. That is what you're being paid for. Okay. So therefore, please appreciate and understand that you have to bring value to the table, and you have to therefore tell the client you don't have locus. You have an alternative efficacious remedy. A client may come to you. I have learned, I have Google searched writ of mandamus. Let's go to the High Court. That is not the answer. If Google was the remedy to lawyers, then in that case, you won't exist. We won't exist. Okay. So therefore, please understand and appreciate, bring value to the table. Simply because some client comes to you saying, I want to do this, does not mean it has to be done. You have to apply your independent mind in delivering advice to your client in a justified manner, explaining why he or she can invoke the writ of mandamus or cannot, keeping in mind the various ingredients which we have discussed. And therefore, please be very clear on the facts, be clear on the grounds, be clear on the research, and ultimately advise your client in the correct manner. Not only because your client wants to do something that you have to toe the line as far as what is to be done. All right. Now, we have the next about 10-15 minutes. Let's deal with a factual scenario. Now, this is, as I said, a live case that I am dealing with. I will also tell you what the ultimate outcome was. I have, as I said, tailor made it to ensure that it's anonymized. But having said that, it's a live case that I'm dealing with. Um, Now you need to understand the facts, because this is what I, as a client, will be coming and telling you, that this is the facts. Ultimately, how you translate that, whether a mandamus lies, whether a writ lies at all of that is something that you need to apply your mind to. Okay. Now, I am ABC. Okay. I am the owner of a bungalow. I am your client. I am the owner of a bungalow in Viman Nagar in Pune. The bungalow is over 50 years old and in a dilapidated condition. So therefore, it needs uh, uh, renovation. Um, so therefore, what do I do? In December 2024, I go to the Pune Municipal Corporation and I say that please allow sanctioning of my plan, because I want to demolish the bungalow and I want to redevelop this entire bungalow. Okay, this is what I end up saying, and therefore I go for a plan sanctioning to the PMC. Uh, all the formalities that I am supposed to do with the plan sanctioning process, I do. This is what you need to ask, but I do. I pay my fees, I fill the challan, I fill all the necessary forms as is required to be done. I give all the maps, I give all the plans, I give all the authority as far as my architect is concerned. So basically, everything that I am supposed to do as the applicant, I do. Okay. In January 2025, in approximately a month, my brother, XYZ, my brother, uh, files an objection with the PMC. He says that I also have rights in this particular property, so don't sanction this plan. Now, this is where the importance of understanding the merits of the matter versus the mandamus will lie. And I will explain that to you. But ultimately, my brother comes, raises an objection, goes to the PMC, don't sanction his plan. I have rights in this particular bungalow. Now, whether those rights are genuine or not genuine is a matter not of mandamus. But we will come to that. Okay. So then ultimately, the matter is presented before the PMC commissioner, who considers whether the objection raised by my brother is genuine or not. And ultimately comes to the conclusion that, okay, I will not sanction the plan for now. I am keeping this on hold. So therefore, I am staying the sanctioning process subject to the final outcome of the matter. So therefore, in the interim, the PMC commissioner grants a stay on the plan sanctioning process, says that hold on in the interim, subject to final outcome. This is fairly regular and normal for public authorities to do. Okay. So therefore, that is what he does. He grants my brother effectively a stay or a injunction against me, saying that the plan sanctioning process will be paused until final outcome of the matter. I am fine with that because I know that I have good merits in the matter. I know that my brother is making false and frivolous allegations, and therefore I'm okay. Ultimately, I know that plan sanctioning has to happen within a reasonable period of time, and therefore I wait for that time to pass. I write a couple of reminders to the PMC commissioner saying, please hold hearings because I want to be heard. I want to argue and present my case to you and ultimately dismiss his objection. And until then, my plan sanctioning process is paused. Okay. So there is a stay operating on that plan sanctioning. But the PMC commissioner does not act. So I write 2 letters, I write multiple reminders. I say, please hold a hearing. Please give me an opportunity of being heard. Please ultimately decide on this particular action and then ultimately decide on my plan sanctioning process. But he does not. And therefore, client comes to me, says that this is exactly what I've done. This is the set of facts. What do I do? So we go through the various ingredients: locus, alternative efficacious remedy. Does a writ lie? Am I filing potentially something premature or too late? We meet all the necessary ingredients. I apply my mind to it. Ultimately, we say that no, a public authority needs to perform its duty. It is not performing its duty. It is leaving me hanging without any reason or rationale. There is a stay on my plan sanctioning process. So I am aggrieved. I am affected by it. All I'm simply saying is give me an outcome. Give me a hearing. Hear my brother's objection. Ultimately decide on my plan sanctioning. But you're not doing it. You as a PMC commissioner. So therefore, we invoke the writ of mandamus. Have you understood these set of facts? Who am I? As far as we are concerned, we represent ABC. Okay. XYZ is my brother. He's the opponent. Ultimately, I am seeking a writ of mandamus against the PMC that please perform your duty because you are not hearing me. You're not hearing and giving me an outcome, and you're therefore not sanctioning my plan in a dilapidated 50-year-old building. All right. Are these facts clear? Because this will be a foundation for ultimately us drafting a writ of mandamus. Any clarity required on these facts? All right. Okay. Is the screen reasonably visible? Are you able to see it? Okay. So I'll just take you through the parts of the petition which I discussed just now. Again, the intent is to some extent, again, you're in the second year, so I'm presenting the draft to you, which ideally I would want out of you. But again, I appreciate and acknowledge and understand the fact that you may not be well equipped to prepare a draft like this. And therefore, I'm showing you how this draft is to be prepared. Okay. In the High Court of Judicature at Bombay, bench at Bombay, it could be bench at Goa, bench at Nagpur, bench at various places. Depending on which state you are in, there may be benches of the court. So it is the Bombay High Court at Nagpur, it is the Bombay High Court at Aurangabad, it is the Bombay High Court at Goa, and it is the Bombay High Court at Bombay. Ordinary original civil jurisdiction, it could vary depending on its appellate jurisdiction, original jurisdiction, whatever it was. Writ petition number dash of 2020, 2025, whatever it may be. What is the matter? It's in the matter of Article 226 of the Constitution. So I'm invoking 226. I'm not invoking 32. In the matter of plan sanction application dated so and so, whatever that date may be, an interim stay order dated so and so issued by the Pune Municipal Commissioner. Now, who am I? I am ABC, age so and so, occupation so and so, residing at so and so. This is the title clause. This is the two parties that you're describing. So therefore, I am the petitioner versus the municipal commissioner, which is the authority that I'm invoking the writ against. The building development department, because that is the department which ultimately will sanction or not sanction my plan. And importantly, again, we started out by saying that a writ petition lies against the public authority. Here lies the slight exception, because ultimately we get down to the principles of natural justice. Why has this entire issue happened? Because my brother raised an objection. He should get his say in court, and therefore I'm making him a party to the proceedings. So therefore he is being made a respondent, but the writ of mandamus is not against him. The writ of mandamus is against 1 and 2. He is being made a party so that he can have his say before a court. Okay. So therefore, private parties can be made parties in a writ petition, although a writ of mandamus is not being invoked against the private party. All right. But I am making him a party in all fairness, because I want him to have his say in court, raise whatever objections, and ultimately get my outcome and get my decision. So these are the respondents to the Chief Justice. Again, these are, to some extent, every High Court will have its own format for how a writ petition is to be addressed. This is the Bombay High Court format. Depending on which court ultimately you present this to, each format may change. The format is largely remains constant of the opening parts, and then comes the main drafting that you need to do. Okay. Now, this is the introductory paragraph, which is what I said was an important aspect that you need to explain to the judge in a few lines as to what that introduction is. It gives context to the judge to understand your entire case as to why you are moving his court. Okay. The petitioner, I, ABC, is aggrieved by the inaction of the respondent number 1 in finally hearing and adjudicating upon the objection raised by the respondent number 3 to the petitioner's plan sanction application dated so and so, filed before the respondent number 2. By granting a stay on the application wide order dated so and so, and not hearing the adjudication or not hearing or adjudicating the matter finally, the respondent number respondent number 1 has acted in an arbitrary, unfair and unreasonable manner, thereby keeping on hold the plan sanctioning process to the prejudice of the petitioner. This is the entire case summarized in a few lines. Okay. Now this gives an opportunity for the judge, when he reads paragraph 1, to understand, okay, I have understood what the issue is. Now let us in that context read what the entire matter is all about. This is the introduction which I was telling you about, which I prefer doing. Now there is no legal requirement for you to do this. You can directly start with the parties. You can directly start with the facts. This is what I prefer. This is the draftsman skill. And ultimately it is for you to adopt or not adopt, ultimately in whatever you're drafting. Introduction of the parties. Now, this is important because it creates the relationship of who is a public authority, who is a private party, what have I done vis-a-vis that party, what has he supposed to be doing, but he has not done, for the court to understand, because you have to understand a court is seeing things in a clean slate manner. So you have to present your entire case to the court. Okay. The petitioner is an individual and owner of bungalow number so-and-so, lane number so-and-so, Viman Nagar. Respondent number 1 is the municipal commissioner of city of Pune. R2 is the authority before whom the petitioner filed an application for demolition of structure and sanctioning of plan. Respondent number 3 is the brother of the petitioner who has raised certain objection to the plan sanction application of the petitioner. R1 and R2 are state under Article 12. This is important because I'm invoking my writ under 226 against a public authority. Please understand and appreciate what is Article 12. That is again the theoretical aspect that I am not getting into, but it is important for you to know. A state under Article 12 of the Constitution of India, and hence amenable to writ jurisdiction of this court. I have specifically left out respondent number 3 because it's a private party. R3 is made as a formal party and no reliefs are sought against respondent number 3. I am not seeking reliefs. Now, please appreciate and understand that a court sitting in a writ jurisdiction is not adjudicating whether his objection is correct, incorrect, valid, or invalid. That is not the court's job in a writ jurisdiction. So the court will not consider whether the objections are correct or incorrect. It will simply tell the municipal commissioner, please do your job and please give them an outcome. What that outcome is, the court will not determine. Background and facts. Petitioner's owner of the aforesaid bungalow. He purchased it from his late father during his father's lifetime by way of sale deed dated so and so. Sale deed is annexed at so and so. Since the structure is an old, dilapidated condition, the petitioner wishes to demolish the structure and build a new structure. In view of this, the petitioner has made an application dated dash to the R2 and also paid appropriate fees. A copy of the entire application with enclosures as well as the fee payment confirmation is at Annexure 2. Again, you need to present to the court the entire matter in a holistic manner, because the next objection should not be that your application was incomplete or you did not pay the fee and therefore it is an incomplete application. We don't want to deal with that. By way of letter dated dash, the R3, which is my brother, raised objections as to the title of the petitioner on the bungalow and claimed to have certain rights on the bungalow. R3 stated that his consent and permission would be needed for demolition or building of the new bungalow as proposed. Copy of the objection dated so and so is attached. In view of this objection, R2 transferred the plan sanction file to the respondent number 1. So the building development department said, okay, you've raised an objection in view of which that there's an adjudication that is required. Therefore, the municipal commissioner will adjudicate upon it. So R2 transferred the file to R1. And this is actually what in reality does end up happening. Okay. R1 scheduled a hearing of the parties on so and so date. Now, of course, the intent is that you have to fill in all the details. You have to fill in all the facts in a particular manner. I'm keeping it blank for now. When the petitioner and the R3 made submissions to their respective advocates, immediately thereafter, the R1 passed an interim order dated so and so, issuing a stay on the plan sanctioning process. Proceedings till final adjudication. A copy of the order dated so and so is annexed. Since then and until today, the R1 has not scheduled any hearings and has not heard the matter. This becomes important for issuing the writ of mandamus. The parties have completed their respective written submissions. The petitioner regularly followed up with the office of the respondent number 1 and the R2. Copies of the reminder and follow-up letters by the petitioner are annexed at Annexure 5. In view of the above, the petitioner is aggrieved by the inaction of the R1 and is therefore constrained to approach this honorable court to invoke its writ jurisdiction and seek appropriate directions. Now, what are the grounds? Now, these grounds is again something that you need to come up with in an intelligent manner. I'm just giving a few examples of how these grounds would typically read. Inaction, and again, keep in mind that this is a mandamus. So I want to tell the court, please tell R1 to ensure that he follows his duties to give me an adjudication. Inaction of R1 in hearing or adjudicating the petitioner's plan sanction application and objection by the R3 after grant of interim stay is unfair, unreasonable, and arbitrary. I want to bring about ingredients of inaction by the state, arbitrariness by the state, which is why I want to go to the court and tell the court, please invoke your, please use your writ command, and then tell the state or the executive to do something. Yes. 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 Yes, absolutely. So reasons is basically giving a snapshot of the entire matter. Okay. It just explains to the court, why have I come to you? It is more like a summary of the entire matter in about 4 or 5 lines. You need not have it. You can completely eliminate that and start with the background and the parties and the facts. But it just gives me as the reader, ultimately, I'm going to be adjudicating on your claim as the High Court or the Supreme Court. I'm going to be adjudicating on your claim. And therefore, I want you as the draftsman to make things easier for me to understand. And therefore, I make it easier for the judge to understand. And therefore, I have written it in that particular manner. Again, no hard and fast rule that it needs to be followed. Is that clear? All right. It is a settled principle of law that while dealing with the public, authority cannot act arbitrarily at its sweet will, like a private individual, deal with any person it pleases, but action must be in conformity with the standard and norms, which is not arbitrary or irrational. Now, these are standard grounds. I will share it with Vasmatkar sir, and he can share this draft with you ahead. I'm not reading it verbatim because I expect that you will understand all of this. But in short, I've raised about 5 or 6 grounds, basically saying that the job that he was supposed to do, he's not doing. Yes. Did anyone want to say anything just now? All right. Now, important, certain boilerplate clauses but important for you to ensure that these are accurate and apply to this particular matter. Petitioner has not filed any petition before the this honorable court or any other court in this respect. So therefore, I am not before two courts seeking the same remedy. Okay, that is what effectively this says. Petitioner has no other alternative efficacious remedy available in law to redress the grievances raised by the petitioner. I can't go anywhere else. Therefore, I'm coming to you. The petitioner has paid appropriate court fees at the time of filing. The petitioners and the respondents are all located. Jurisdiction, very important. Why does it go to the Bombay High Court and why not to, say, potentially the Gujarat High Court? Why does it go there? The petitioner and respondents are all located in Pune, Maharashtra. The entire cause of action has arisen within the jurisdiction of this honorable court, and hence this honorable court has jurisdiction to try and entertain this petition. There is no delay or laches on the part of the petitioner in approaching this honorable court. The petitioner will rely on documents, a list whereof is annexed. Prayers, very important. Under the circumstances, please allow this petition. Prayer number 2 becomes most important. Honorable court may be pleased to issue a writ of mandamus or any other appropriate writ. Now, this is standard language that we use in a prayer because I want to keep myself open to invoking multiple writs potentially, or the court using its discretion saying, oh, mandamus may not apply, but I will quash the interim order as an example. Because again, my focus here is to teach you mandamus, but ultimately when given the set of real facts that you will be invoking multiple potential writs, and therefore you don't want to only restrict yourself to mandamus, because ultimately the court should not say you've asked for mandamus doesn't lie, I will not grant it to you. Keep your foot in the door open. Under 226 of the Constitution, directing R1 to hear and adjudicate upon the petitioner's plan sanctioning. Very important, the prayer does not say that dismiss the objection, don't consider the objection, grant me my plan sanction. It does not say that. It simply says hear and adjudicate upon my application. Okay, because a writ court is not sitting in appeal. So the merits of my brother's challenge to my title is not forming part of this writ. Be pleased to issue costs in favor of the petitioner. Be pleased to pass any other orders, directions. This is a residuary clause. So and so February, ABC signs, I as the lawyer sign. There's a verification clause. Each high court will have a requirement for either verification, supporting affidavit, whatever it may be, depending on the format. And that is where we stand. So that's the entire lecture for you. I end with explaining this writ of mandamus. So my intent was to give you basic tips of drafting, explain the writs to you, explain mandamus to you, and ultimately show you a live example of how a writ of mandamus works in reality and what you should be considering. So any questions, any issues, any points of consideration, anything? Yes. No, grounds is not cause of action. Grounds is the reason why I am invoking the writ jurisdiction. Cause of action is basically what wrong has happened. So cause of action is more used under CPC in a plaint. Cause of action is typically not used in a writ. Grounds as to why I am invoking writ petition is not necessarily a cause of action. Cause of action is a bundle of facts. Now that is again getting into your CPC understanding of cause of action, which I don't want to get into at this stage, but cause of action and grounds are different. Sorry, a little louder, please. Yes. Yeah. Law fact approach. Yes. Yeah. So see, please appreciate and understand that moot courts are, intended to prepare you for, ensuring that you present a matter appropriately. But having said that, it's still very theoretical in nature. A lot of times you don't plead the law in your pleadings or in your petitions, you argue it. But because it's an adjudication process that we have to go through as moot court judges, we therefore have to see your understanding. We have to rate you on your memo, various things. So that is not something that I would say will stand replicated as far as a petition or a suit is concerned. That is not how it's typically done. Moot courts are more theoretical in nature. What really happens in court is, I would say, quite different, not completely different, but it's a stepping stone for your understanding. So moot courts prepares you for drafting, prepares you for arguments, prepares you for presentation of arguments, all of that. But it's still very theoretical in nature. It happens very differently in reality. Yes. Any other inputs? All right. So then I'll conclude for the day. Yes. Yes, please. Yes. 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 Again, that's a draftsman's skill. So ultimately, there's no absolute format that it has to be in that particular manner. Ultimately, the court has to recognize that this is a prayer clause. So therefore, the courts don't go by a hard and fast rule. Moot courts do go by it simply because there is a marking system that we need to adopt for marking you on a particular format. So you will follow, say, something known as a blue book format, as an example. So that is something that does not really work in reality. All right, not all the time. Yes. So that is ultimately your skill, no? That is the experience that you will be picking up. So it is not something that I can give you an answer that you have to add it or you don't have to add it. That is ultimately the skill that you will be once you go through 10 petitions. See, when you graduate from law school, you're not going to go and sit in court and draft petitions or draft suits. That's not going to happen practically. Yeah, and if it happens, it's going to be a disaster. Okay. So therefore, in reality, you will be guided by your firm, your senior, some chamber that you're part of. You will go through multiple drafts. You will go through multiple mistakes. There will be debates and discussions that will happen between your senior and yourself in terms of what should or should not be done. And ultimately, you will come to that. So therefore, I can't really answer when something is to be done. That is dependent on the facts and circumstances of each matter and the application of mind that you have to do and the value that you have to add as a lawyer. Yeah. All right. All right. Okay. Okay. Yes. 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 Okay. Yes. Oh, yes, absolutely. We encounter it very regularly. But so there are two types of clients and opponents that you will typically have. One is you will have a relatively sophisticated client or set of clients who will be able to present documents or present or understand documents in a proper manner. And then you will have clients who are not very well versed with the law or the understanding of how to capture a particular contract. So yes, I mean, can there be fear? Yes, there is fear of doctors, there is fear of lawyers, there is fear of putting pen on paper and presenting a contract. And that's why ultimately you have to sit a person down, because see, lawyering as a skill is not only about the law. It is about how you deal with a client, how you deal with a judge, how you deal with the opposing side. And this is all about human relationships. So it is not an absolute issue that you only have to deal with law. So therefore, you will have to deal with tough negotiators. You will have to deal in a situation where you are the weak party, the opposing party is a strong party, or vice versa. So therefore, depending on who you are and who you are representing, you will have to um, tailor your advice or tailor your actions upon the given set of facts and circumstances, because it's not pure science. It's not right or wrong. It's not black or white. It's not going to be like that. Again, ultimately, you have to realize that ultimately it will be a matter of skill, it will be a matter of experience, it will be a matter of cajoling, pushing, negotiating. These are all skills that ultimately you have to imbibe as lawyers. Some part will be taught to you, some part you have to learn, through experiences. Beyond the point, law school has its limitations of what it can teach you. So at some point, you have to fall, you have to scrape your knees, you have to get up, and you have to learn it. There's no two ways about it. Yeah. Yes. Well, uh, I mean, under certain circumstances, yes, you do it with a conscious decision being taken by your client, saying that we are letting go of these 3 or 4 clauses. This is what the potential consequence can be. And ultimately, if you and your client are on the same page, then you do it. No difficulty. But I mean, if you're taking away the consideration clause, it's a no go. If you're taking away the title clause, it's a no go. So therefore, you have to apply your mind to what is it that you are eliminating, or can it be covered in a slightly more subtle manner in a different part of the contract? So it can be done, but it needs to be done a little intelligently. Yes. Anyone else? Okay, can we close for the day? Okay, thank you very much.
Once again, thank you so much for your time and patience, and thank you for taking out the time of your busy day and delivering the lectures to the students. I hope the students really benefited from this class, and it really gave them a very practical insight into drafting a writ of mandamus. And also, I would like to thank sir for also giving us certain general instructions as to how to draft a petition in general in courts. So, thank you, sir. Thank you for coming. And I would also like to take this opportunity to thank the IT team to facilitate this, our co-faculties who have been working on scheduling the lecture. And also, I would like to thank Dr. Shashikala Gurpur ma'am, Dean, School of Law, Symbiosis Law School, Pune, for providing us with the ample resources to schedule and carry forward with these lecture. Last but not least, I would like to thank all the students for paying enough attention and also gaining from the process a lot. So thank you all. Uh, take the 10. Guys, please, only have 10 minutes left. So division A from 1 to 35. Uh, please, 3. 27. 5. 1 5. 1 1 7. I'm asking page wise, please wait. 37 to 63. Didn't I call the first page earlier? A division, A division. Division A, 37 to 63. Yes. Sixty-four to 81, division A. 70, right? 71. Division B, 103 to 145. 1. One. Sorry. 122. 113. 9. Sorry? 74. 174. Should pay attention while taking, no? Guys, division B 146 to 184. 180. Yeah. Next. 158. 9. 158. Please tell your parents. 186. Division C 201 to 228. 219. 21. 229 to 260. 8. 261 to 283. Division D 301 to 30333. Yes. Hmm. Haven't called yet. 334 to 363. 3 337. 365 to 388. 77. Division E 401 to 430. 415. 418. 431 to 466. 468 to 89. 60. 4. 4. What were you doing? Everyone else gave your yes. Section A 29. Hope everyone gave your attendance. Thank you.